At your confirmation hearing, you characterized what happened on January 6th as, quote, a heinous attack that sought to disrupt a cornerstone of our democracy. I agree with that. And in your written testimony today, you point out that the intelligence community has identified domestic violent extremists as the primary threat to our nation, and further note that your department is committed to keeping our country safe by protecting our democratic institutions. I would note that protecting our democratic institutions is not limited to the Department of Justice. The Congress also has that obligation to protect our democracy. To that end, we have a select committee that is reviewing the events leading up to January 6th and has a legislative mandate to devise legislative recommendations to prevent future acts of domestic extremist violence, to strengthen the resiliency of our nation's democratic institutions, to propose laws that will keep our democratic systems safer. Now, with that background in mind, we are, as you're aware, seeking information to inform us to perform that role. Before you were AG, you were a judge, and I note that in your judicial role, in 2004, there was a case, Judicial Watch versus the Department of Justice, where the court ruled, quote, presidential communications privilege applies only to documents solicited and received by the president or his immediate White House advisors who have broad and significant responsibility for investigating and formulating the advice to be given to the president. I think you're familiar with that case. Do you think that's still good law?
Yeah, I think the D.C. Circuit is a good source of law.
In the Supreme Court case Nixon versus administrator of GSA 1974, the Judicial Watch case actually relied on that precedent. That case said that the communications to advise the president would be only on official government matters. Do you think that's still good law?
I think the Supreme Court's opinion is still good law until it's reversed, and I see no sign that it's going to be reversed.
We were here in the Judiciary Committee pursuing testimony from Mr. McGahn, and the court wrote in the 2019 case, and this is a quote, to make the point as plain as possible, it is clear to this court for the reasons explained above that with respect to senior level aides, absolute immunity from compelled congressional process simply does not exist. Do you think that's still good law?
I believe the McGahn case is still good law.
Recently, the Department of Justice informed a federal district court that, quote, conspiring to prevent the lawful certification of the 2020 election and to injure members of Congress and inciting the riot at the Capitol, quote, would plainly fall outside the scope of employment of an officer or employee of the United States of America. Since your department filed that, I assume you agree with that?
Yes.
So I just want to mention, I'm not going to ask you about what your department will do if the House of Representatives adopts a referral to your department, because I take you at your word that you will follow the precedent, you will follow the law in the ordinary course of events. I would just note that your defense of the rule of law for the Department of Justice and your standing for the rule of law also means the rule of law for the Congress of the United States. Article 1 was the first article for a reason. We have a role to play in making sure that our democratic institutions are defended. I thank you for your service to our country, and I look forward to your deliberations so that the Congress of the United States can play its rightful role in defending our institutions and adopting legislation that will strengthen our institutions and preserve and protect our democratic republic. With that, Mr. Chairman, I yield back.